let's go ahead. So today we are going to more focus on introduction to trademarks, how to get trademarks registered, about international trademarks, and what are the best practices for startups and small businesses to go about their trademark registration, and a couple of case studies to take inspiration or learn from, and we shall conclude the presentation then. So intellectual property is anything with any creation that comes out of the mind, and depending on the form of that creation we have various kinds of intellectual property to cover it in. So of course, as Archana said, our presentation today is going to be focused on trademark. Now trademark is something which can be graphically represented according to the Trademark Act, and something which has the capability of distinguishing the goods or services of a business. So, of your own business, it should be able to distinguish you from some third party. So, a trademark may include shape of goods, color combination, a word, a design which you put into it, a unique symbol as such. So, you can see many examples of the same on the screen. Let's go. So, why trademark? What is the purpose of a trademark? First of all, the core purpose of a trademark is to avoid public confusion and to let public know that where their goods or services are originating from, which brings quality assurance as well and customer loyalty as well for businesses. But since we are focusing on startups today, let's focus on what is the purpose of trademark and what is it creating for startups. So for startups, a trademark is creating an enforceable ownership rights, and it is creating a mechanism to trade in brands, and it is providing with rights to exploit them commercially. Now, how can one exploit them commercially? Well, trademark is a formal property right, and it can be licensed and it can be sold as well. So it creates many enforceable right. Now, trademark also provides with clarity on ownership and gives you exploitation rights of your mark within a territory, within a jurisdiction, of course. Now, a time you have spent in building your business or building your products, and giving them a name, protecting them. It Trademark is a legal mechanism to protect your investment, your monetary investment as well, your time investment as well, and to build reputation as well within the whole market. So all these things which trademark enables for a brand, for a startup or a small business, leads to prevent unfair competition as well and theft as well. So nobody can suddenly come up with a similar looking mark of yours and get a share of your client base which you have worked hard for. So these are many of the reasons why one should file for a trademark. And filing for a trademark, one of the add-on benefits would be to pursue infringers, to use notices, to license your trademarks, and to have monetary benefits from them. All this along with legal protection on your side.
So just want to highlight over here, right? So this is basically related to the intellectual property. That is one of the main type of the intellectual property, that is trademark. So it will give you the protection in a specific territory for a specific period of time, and it will also give you the exclusive right to exclude others from using your trademark without your permission. So this particular right, the trademark will give you. That is called as a legal protection. Licensing, that means as you have your other properties, for example, your own car or house, that is called as tangible property. So intellectual property is considered as intangible property. You cannot touch and feel that property, but you have the ownership of that property. So in other cases, like as you sell your house, that is called as assignment of intellectual property, and as you give it on a rent, that is called as licensing of intellectual property or a trademark to other person to use in a specific territory for a specific period of time and for a specific purpose. So licensing means the ownership will retain with you, but you are giving it on a you can gain the royalty and you can giving it to somebody else to market this particular intellectual property for a specific period of time. So the preventive measures that means it will give you the legal right to exclude others. They cannot use your trademark without your permission. You can pursue the infringers. You will gain the monetary benefits out of it once you establish the brand in the market. And it will use of notices that Kirti will cover later on. That means how you can use these notices, how you can put this TM and R on your trademarks. So that's all that is related to why to file trademark. So please carry on.
Let's continue with different types of trademarks. So, to look at types of trademarks, we'll go with the flow and see that arbitrary or fanciful trademarks. Now, these are the kinds of trademarks that hold no relevant meaning in the market. So they don't have or relate to any goods or services and exactly mean them. So dove is a coined word and it does not have any meaning in the goods that it is selling. Dove is for a soap, of course. So dove is originally a name of a bird. So having no related meaning, nobody is going to confuse them for it. Next would be suggestive mark. Such marks requires an observer to go through several levels of understanding before relating to the mark. So everyday use for batteries is one of such marks that you have to really understand that what do they mean by being by saying calling their product as ever ready. Another one would be suggestive. Suggestive would be this, sorry. Then descriptive. Now, descriptive mark, it's such a mark which is descriptive or indicates towards a kind or a quality of the product or the service they are providing as such. Now, these marks are usually typically very weak to register as well, and these can only be registered when they have shown that they have been using this mark for a good amount of time for continuous use is there shown in throughout years. Next would be coined and invented marks. Coined and invented marks are one of the most good and strong marks. Now, we'll get into it that what good or strong marks means later on. So these marks are invented by the invented by the owner themselves, and it holds no meaning in customary language as well, or anywhere in the language of English as well. It holds no meaning, so it is just a letters put together and being created as a brand. So this becomes one of the most easily registrable and with more protection, and no other person is going to easily be able to infringe your mark as well. Next, we will look at generic marks. Now, these terms or marks are as such they have very common meanings of goods and services. So here we are taking the example of adhesive bandages. Okay, adhesive bandages, the Band-Aid. This was the mark created by some company to use for adhesive bandages. But this mark this got so famous that it suddenly became a very common word, or in the colloquial language, it took a place and people started to use it. So it became very generic mark. So any other example for generic mark would be like using chair to sell chairs. So this makes the mark very potentially not easily registrable and has very extremely low chances of registration as well. So these are the 5 types of marks. Next, we are going to look at kinds of mark. Yes. So kinds of marks. Now, there's a difference between types of marks and kinds of marks. The only difference it would hold is that types of marks is what it talks about the mark. It does not. It talks about the quality. What are the quality that mark hold itself? Like, is it coined or invented mark? Does it have any meaning, or how is it going to relate to it to the product itself? Kinds of mark we are talking about, like word mark. Word mark is any standard character written plainly. It could be numeral, it could be a combination of letters or just a words put together. So here we are taking the example of Disney. Now, both of these device marks which we have shown, the logo, these both would be covered if the mark of the word mark of the Disney itself is covered. As of now, Disney does not hold a word mark, but these both devices which they have already registered are already covered. So if one wants a word mark, which is a very strong mark to hold, but very hard to register as well. Okay. Next would be device mark. If you include any label, sticker, logo, or image, or a monogram or a geometrical figure as such to represent your product or your services, then that would be called as device mark. So here we take the example of Adidas, and next we move on to sound mark. So sound mark as such, just does anybody recognize this mark? No one?
I think the audio is not shared, so
No?
we were not able to share it. But it's okay. I think we'll have
Okay.
to share and everything. We can.
Okay, so we'll go ahead with this. Sound mark, I've said here, sound mark is just any kind of sound which, and sound mark yet has to be graphically represented. So we'll get to that question, that how can it be registered. So we get the notes, we can see the notes on the applications, and it allows for registration then. Next, we will be looking at three-dimensional marks, which are basically shape marks, and a unique shape has to be registered, which holds no element for use as such. Means it should not have any technical use in the product, but rather is there for design. So that is registered within three-dimensional trademark. Next would be color. When a color combination or a certain color has been used for, say, packaging or any other thing, so it becomes very famous. So the quiz you took, it had the options of color. So one color of purple or a Pantone color, to be specific, was of the Cadbury, and the other orange which we took was actually one of the core colors of Amazon. So but one of them is actually registered because it has claimed that registration and become so famous through its packaging and its logo design. Okay, these were the kinds of trademarks. Next, we are going to look at some of the other trademarks like certification marks now. Certification marks are used by entities for certifying the characteristics of goods or services as being of a certain kind or quality as well. So these are usually used by independent organizations, and it becomes sort of a standard thing that some organization like Indian Standards Institution, if it gives that hallmark kind of thing to the products, then it is taken that they are going to be of some quality. So some quality assurance is provided via these certification marks, and these can only be held by independent organizations who are not using or doing a service or selling that same product in the market. Next would be collective mark. There's a big difference, though sometimes certification mark and collective mark are confused with each other, but there's a big difference between these marks. Certification mark are held by independent organizations. They have nothing to do with the products as such in the market, like ISI. Next would be collective mark as such. They have a member of association for a particular goods or service, and they own the trademark as the association themselves. They might not already, like they might not trade or use the mark directly in the market itself, but they let their members of an association use that mark to make sure to give a kind of assurance to the public that they have some basic standards because they are using the mark. So one such example would be Institute of Chartered Accountants. We have for many different professions similar institutions which put together have such communities or associations to their name, which lets us know that they have some kind of quality there available. Now, okay, next would be series marks. Series marks are very similar marks, yet they are very different in many small and minor non-distinctive characters. For example, you can see would be Lay's, because Lay's has different flavors and they use different kind of packaging for them and colors, and they have the mark as same. So this shows that they have all registered the same similar kind of product with different trademarks, but in the series of it. It's like a pool of trademarks available there. So moving on, well-known marks. well-known mark is something which is like widely recognized by general public, and it is associated with the product company or the brand itself. So these marks, these often are known as famous trademarks, but to be well-known trademarks, you have to be recognized by some judiciary body to make sure that your association, the association of this mark is directly with the company, and very less amount of public is actually not relating to it. Okay. So these well-known marks enjoy a special kind of protection in trademark law because they are so famous that their association in any other product or service which maybe the company is not doing any business in, even if they are used there, the public would be confused. So because of that, they have certain kind of special status available in the trademark law, and that is why they are well known. So now, when we there is such a wide or vast business available in this market. So how are we going to know that which trademark is in which sort of business and which company is trading there? So to standardize this process, I think there is a classification done for goods and services. Now, these classification is basically that different products and services are divided for the purpose of trademark in different classes. So there are 45 number of classes, and 1 to 34 means 34 classes are for goods itself and wide range of goods, and 35 to 45 means 11 classes are for services. So any kind of goods we have which will fall under one class 1 to 34, and any kind of service any business is providing falls under class from 35 to 45. Now now, these are just two examples that we have put forward here to see that different businesses, how they are protecting their trademarks by bringing them under certain class. So it is very important, and we'll go to this further ahead in the presentation, that how we have to clearly define our services to make sure that we file our trademarks in the right class itself. So Geo has protected their Geo mark in class 9, which is for computer software electronics, 35, which is for business services, 38 and 42, which are for telecommunications and technology services. Now, one might confuse themselves between class 9 and 42, saying that they are pretty much like having software or software services. But we have to go back and remember that class 9 is falls under goods. So it's product based entirely, and class 42 falls for services. So they are going to be divided. So any software product would come under class 9, and software service we are providing, some businesses providing, which fall under class 42. Similarly, Flipkart has also protected their mark within these classes, and including further, they have protected it in class 16 as well, which is for paper, books and stationery services, and 41, which is for education, entertainment and training. Now, these are still very limited amount of classes to protect your mark under. There are many well-known marks or not necessarily well-known, like suppose Amazon. These are the marks which they have protected their mark in all of 45 classes. So such businesses exist, and it's very much relevant to them to protect their trademark in such a manner. Next, we will look at trademark availability search. When we are thinking of filing a trademark, we have to first know that what all other marks exist in the market or on the registry's books, to know that we are not infringing someone's mark, and that our mark, which we have maybe coined or maybe we are designing, that is of unique quality and it has that element of distinctiveness, which we'll explore further. So trademark availability search has many different databases and websites we can go through. Every country has as such their IP website to conduct an availability search on, and we'll conduct this availability search with the mark and the class. So we are going to first define our services and then go to do a thorough public search. And there's a global brand database available as well, which is for brands globally, of course, as the name suggests. And let's look at a video here that we are showing, and this is going to be for just public search of done on IP India websites for two of the marks, one of them which have filed, and how you can look into that your mark has some relevance. Okay. Is it visible? If anyone can answer in the chat box. So here what we are doing is that this website has many different columns to choose from, drop boxes. So we are choosing contains as such, not other options, because contains would actually have from start and compare your mark entirely with whatever marks are on the registry. And you have to put in your class and only enter one class at a time and see that there are results. Now these are the marks which are, one is accepted, one is objected, and we'll further go into it. Similarly, for this other mark, we are doing the same.
Hello?
Yes.
Yeah, so there are two questions. I think it's an appropriate time to take them. One is from Neeraj. Is logo and brand name both together registered as a trademark?
Well, not necessarily. So logo and brand name, okay. Brand name, you might relate to them with a word mark, and logo might be your image which you have designed. So you can make a call the whether you want to go with the simultaneous application, or go ahead with registering one of them first and then following it up with the registration. Because since trademark is an investment, we are making that investment, and we are thinking that if both the applications are not going ahead on the speed that we are hoping for, then it would be maybe problematic, or someone would not prefer this situation. So one can go ahead with, depending on how good of a result they get from public search and how clearly they have defined their application, that we should go ahead with first logo or just brand name. Brand name, if that is just word mark. If we are talking about here different brand name, which is again in the form of a image or a logo, then yes, simultaneous applications is no big deal. I think that answers the question. And can't we search in one go for all the unfortunately, we can't yet. IP India website does not facilitate that. But yes, when we search in global brand database, there is a provision that we can search in advanced search, and we can add all the classes that we want to go into, go for a search for. And we also actually have a provision that if we have a logo design, we can just upload our logo and look for phonetic similarity. So I'm gonna continue playing the video right now. If there's any other question, we can take them later on. Now here we are using a different class, similar mark, and we have the similar objection. But here you can see that this mark was such nicely coined mark with multi-layered meaning to it, that it had no other objections or similar looking marks on the registry. These are both of the same company's mark, and one of it is accepted, one of it is in the process of getting accepted. Okay. Just a second. Okay. Sorry about that. Something with the. Yes. Let's move ahead and look into, now we have defined our classes, that what are the classes we are going to do into, and we have been through the IP search for public search on IP India website. Now let's get to the process of how a trademark is registered. So there is this flow chart. Now we are going to briefly go through it, and you can further look into it. So for startup, firstly, or small businesses, a trademark application is can be made in, you can make one mark in one class as well, and you can go for multiple classes as well. Means one application but multiple classes. Okay, this just makes your application one and you have multiple classes, but it does not cut down on cost or any other things. It will give you the same amount of objections or acceptance or whatever your outcome is going to be, it's going to be the same. It's just that it provides the facility of making one application and adding multiple classes to it. Next, so the statutory fees which Registry of Trademark takes for startups is 4,500 is for e-filing and 5,000 is for physical filing here. So once this application is made, the next important step would be to, if you have filled your application details entirely correctly, next should be examination report. Now, examination report can lead to acceptance of the mark directly. And if the mark is accepted, what happens next is that it is published in a journal for 4 months of time. And after that 4 months, that 4 months of time is allotted to let other third party to provide an opposition to your mark that we do not want this mark to be registered. And if you get a notice of opposition from some third party within that 4 months, then you will lead towards opposition proceedings. And if not, then your mark will move ahead with registration and you will get a certificate which will be for 10 years of term and which has to be renewed. But this is when it is directly accepted. Next would be if it is objected. A mark is objected within a certain grounds, which we'll be discussing later. But when it's objected, we reply with an reply to examination report within 1 month of time, and then we have a hearing ahead with examiner, and further decision is rendered, and we can go ahead with appealing to the mark, or we can go ahead with our mark being registered as accepted, and then again the flow of things go. And this whole process can take up to a year or more than time of that. Just yes. So as we were talking about examination report, which holds grounds of refusal. Now, what are the bases that this refusal is granted? Maybe or what are the objections we are gonna get? So we are gonna talk about that now. First of refusal is absolute grounds of refusal. Now, absolute grounds of refusal pertain to characteristics or traits or any grounds of refusal which have direct relation to the mark under examination. So you're gonna see any mark which has no characteristic or which is devoid of any distinctive character, which is very plain and not being able to relate to the mark or represent a product or service, then it is not registrable. Or any mark which causes any confusion to the public, hurts any religious sensibilities, or had some obscene matter, it is not registrable, or it is not allowed in certain acts as possible, or has some elements which are not registrable according to these grounds itself. Absolute grounds are typically harder to defend because it pertains to your mark itself, that you have not chosen or coined or designed a great mark to a good mark to be registered at, which is the concept which we are gonna dive into further. Another type of grounds of refusal are relative grounds of refusal, which are slightly easy than absolute ground of refusal to defend. Now, relative grounds of refusal pertains to already existing marks on the books. So these marks, already existing marks, these marks may suffer after your registration is granted. So a new registration of a similar mark will allow them to have something. Okay. So any mark which is, let's suppose, deceptively similar to the mark or similar to or identical to any mark which is already there, whether it's well known, whether it's third party, it is not allowed to be registered. Whether it's similar class or services or products or different of them, or it will suggest any public confusion. These marks are not going to be able to register without these objections. So relative grounds pertain to these kind of objections. Like, for example, you may have seen that for fast track, there's a counterfeit goods called first track. So nobody can register that as a trademark because it is similar to a already um, present mark on the box. Now, after all these grounds of refusal and after you have gone through the process, this is the registration certificate which you'll obtain uh, in the end, and this is going to be providing you with a 10-year of term to a right towards your mark. And if you are able to show continuous use of the mark, then you can renew your mark and again gain a protection for of 10 years and go ahead with it. Now next would be use of TM and R notices. Now these notices, these are sort of source identifier for goods and services. So we are going to talk about first TM notice. Now when do you use this notice is that when your trademark is ready and it is in process of registration. You have applied for the trademark, it has not reached the stage of registration yet. That is when you use these marks, and it is used for unregistered trademarks and service marks both. Now TM, what it does is it renders common law trademark rights. So there are two kinds of rights. One is unregistered trademarks have common law trademark right, which pertains to public confusion, that public should not be confused. That is why they are getting these rights, to make sure that there is no counterfeit goods available in the market. TM gives you that nature of rights. Next, we'll go to R. R in a circle is when your mark is registered. So any registered trademark uses, like here, Himalaya using is a TM or the top right corner of their mark, and Adidas is using R. So Adidas is already a registered trademark, and it is only used for registered trademark, and it renders ownership rights in trademark law itself. So this renders it to you as such that you have ownership rights within a jurisdiction, and nobody is allowed to use your mark to sell their goods which are not going to be the same, because these marks have your like the scheming. Now how to use these symbols is that you have to put it on the top right corner. You have to use only where they are going to be legally present, means there is a jurisdiction involved, and they are not to be used on any legal papers. Next, we are going to look at international trademark and branding. So for international trademarks, to reach that level of global branding, we have a one-stop solution called Madrid protocol, Madrid system. So Madrid system has two agreements, which is Madrid Agreement and Madrid Protocol. Both of them are administered by International Bureau and World Intellectual Property Organization. This allows you to make one application in one set of fees, which is calculated, and the application is made in one language, but this lets you or enables you to protect your marks within multiple territories and to extend your branding, like your protection geographically. Now, around 130 states are all like completely party to Madrid Agreement as well as Madrid Protocol itself. There are two types of registration you can make, but both of these are dependent on your registration or your application in your national countries itself, which is basic application and basic registration. So if you suppose you have made an application in your home country, then on the basis of that application, you can make a application in Madrid system. Or if you already have a registered mark, then you can make a registration via basic registration, and they streamline this whole process. Next, we'll look into the concept of good and bad trademark, good or strong and bad or weak. So what is a good trademark? Good trademark is something which has these set of qualities in it, which will make it easily protectable and hard to infringe or hard to copy as such, and it will give you enough set of evidences to prove that you are the owner. So one of those qualities would be distinctiveness. No, distinctiveness means that any element, any design, or any coin term which can enable you to distinguish your mark from others in the market. The whole quality of distinctiveness talks about it. Another quality would be your mark should be easy to pronounce, remember, spell, spell. You should be able to write your mark legibly. It should appeal to the eyes as well as ears. Means if it's a word mark, only to the ears, of course. But if you have a logo, it should be easily recognizable. It should satisfy any registration requirements as well, and preferably it should be in one word. Your mark can be not descriptive yet suggestive of some quality. Like we previously saw that ever ready is one such mark which keeps two layers of understanding or realization taken. Your mark should be short but yet effective. Like suppose we can take an example of Nike, which is a very famous brand for shoes. So it is very easy to say as well, and it is a coined term as well, which has no relevant meaning as such. So invented and coined words are the most good or strong trademarks we have. Another example would be Amazon. As you can see that they have used this arrow of a smile made, and which they take it from A to Z, depicting that they have a wide range of products to be sold on their website. And Amazon is not a coin mark, but it is an arbitrary or fanciful mark because Amazon is a forest and nobody relates it to a e-commerce website. Next would be a weak mark example would be the multinational company, which is in the industry of healthcare, worker safety, and it was initially incorporated as Minnesota Mining and Manufacturing. As you can see, this is a very long trademark for people to remember, and they have later on adopted the logo of 3M. Next, we will look at some best practices for trademark registration, and we'll go through the same with steps to go for trademark registration. One would be to spend as much time as you need to come up with the brand name and to create a very good distinctive mark. Next would be first would be a very good public search, a thorough, clear, comprehensive public search, making sure that you have no other marks on the market which are maybe in the goods, similar goods or services. To make towards trademark registration, next step would be to define to have a very set of clarity of what goods and services or what classes you are going to register under. Next would be to compare your mark with a good or distinctive trademark and to take inspiration from that. Next step would be to use your mark. As soon as your trademark is ready, you should start using it, and you should have documentary evidences to show that you have been using your mark. You can use this on invoices or any kind of documentation for marketing, social media, or anywhere, because use of a trademark gives title to it, and this giving this title or use by a person or business, it falls under a property right, and law protects that right. So using is very important. Another would be by creating a mark, you can use multi-layered meaning to that mark, like many famous brands have done. And uh, it would be just a suggestion to use or create new names for your new products. Rather, if the company name is one, but you have a wide range of products, you can have many different trademarks for it. Second last step would be to prosecute, means make your application, make sure all the deadlines are followed, have a good set of responses done, and go through the waiting period. And then would be to maintain, to monitor and enforce your rights, means if someone else is infringing over your products, you uh, prosecute them. And then would be timely renewal, of course, that which is like maintaining your mark. Now we'll be talking about trademark dilution, genericide, and infringement. Now these are the phenomena which are not good for trademarks and hence are to be avoided. So trademark dilution. Now trademark dilution is when somebody trademark dilution is more on the surface of trademark infringement, but it is for famous marks. So dilution of a trademark can be done by some other party while they are not maybe not giving infringing goods or providing those in the market, but they are tarnishing your image, your already registered or visible or famous mark. They are tarnishing your image by creating a similar looking mark with certain elements. So here you can see the example of Starbucks and Starbucks. So they might have the same coffee or cafe, or the quality of goods might not be that much that low of a quality. All these things do not pertain, but a registered trademark is having their reputation under question after having a similar tarnishing mark on the in the market. So this refers to dilution. Next would be genericide. A mark when it becomes overtly famous, like Xerox, like we don't anymore call photocopy, but we rather call Xerox, even though it is a brand name and it's not a common language word here. So when it becomes a common word and public starts using it, when the mark becomes so famous and has such visibility available, that it becomes a very generic word and anyone can use it now. So your mark now goes off to being nothing as such, because it is not distinguishing you from any third parties available. Now, next we'll be talking about trademark infringement. As you can see, Wix. Wix is a very famous trademark, and it has a very good three-dimensional green emblem, which looks very modern and easily identifiable mark, because it is very famous in the market. Now, there are many counterfeit products available in the market, and they are using a similar design of that triangular shape or a similar color combination and selling those products. Now, this is what trademark infringement is. Now, looking at case studies to take inspiration from, one of them would be that how even smaller level of businesses can take up many big companies who are not really pertaining to the laws as suggested. So one of these case studies would be Mom and Me by Baby Okay. So as you can see, Me and Moms, this was the trademark brand for pertaining to mothers or parents or maternity clothes and baby service, baby products as such available, and they have been in the market since 1994. Recently, in 2008, Mahindra Retail launched this mark in the same line of products and services called Mom and Me. So, Me and Mom and Me, as you can see, it's very similar. But they still launched this mark, and maybe due to insufficient availability search or whatever the reasons might be, this launching of this mark invited a dispute from the Me and Mom's company, and that dispute led to Mahindra, abandoning the mark itself, and then they acquired a new mark, which is, as you can see here, Mom and Me is now Baby Oil. Baby Oil was a budding company and which was acquired by Mahindra, and this whole process actually cost Mahindra a great loss and a lot of criticism and media backlash. So, but this proved that trademark use, if you show enough use in front of the court or the this, you can take up a very big company as well, because you already have your reputation, your everything done into that one mark. Next would be to take inspiration from would be a trademark called Tata. Of course, Tata is very famous, but why are they famous really? Because of their quick approach and creating opportunity in disaster. Tata is pertaining to trademark also, it has a very great strategy, and when it comes to brand as well, it is a very reputed brand. But we are going to focus on trademarks. So for trademarks, Tata has this great logo here, and Tata has been using its mark for different kind of services as well. So you'll see Tata Steel, TCS, or many other marks. But does anyone know that Tata has many different product lines as well, which are not using Tata as a brand? They are using Tanaira for clothing lines, maybe Tanishq for jewelry line, maybe. So they are building new trademarks for their new products and having a strategy to maintain them, to make them famous and gain their own reputation, and not diluting their already registered trademarks here. So an independent set of businesses with such creativity is what becomes leads to smart or strong trademarks on the books, which is equal to good trademarks. So To conclude our presentation here, we will just concluded with protect your IP. Any kind of intellectual property in business is worth protecting, and to make you good use of your IP to generate wealth and to commercialize it and to protect your reputation of your business effectively. It's really required. And the next would be a very underrated conclusion would be to track your IP. Tracking and being aware of your IP potential in every arena is extremely important for startups, because initially they might not mean so much, but with time your reputation will be holding on to this your brand, or your brand will be built from your trademark itself. So be not be to not be open to harmful transactions. You have to track your IP and be aware of your rights as well. So we are going to conclude our presentation here, and just to talk about TechX.in facilitation services for trademarks. Here we provide advisory and facilitation and assistance related to trademark services, which includes procedure, costs, timelines, strategizing, and helping with the availability search or documentation and physical filing at the Indian Trademark Office. And further prosecution means examination report responding and hearing assistance as well. So these are the services we provide here, which are entirely advisory and facilitation services. Next would be, these are the trademarks that we have until now filed. Many of them are registered and in process of getting registered, and you can see many famous names here as well. These are the references for the PPT which I have shared here, and anyone could go and further read this trademark. And if we have any questions, we'll be taking them now. So
Hello?
yes.
Yes, so I'm pasting the feedback form.
Okay.
Okay.
Just
So everybody, please paste your questions in the chat box. Archana and I'll be taking those questions now. And please,
You can paste your
yeah.
questions in the chat box, as well as you can unmute yourself and ask the
Yes.
questions.
And you can further go ahead and fill the feedback form for this session and how useful it was. Thank you.
Yeah,
Okay.
so you can raise your hand in case you want to ask questions, but there are a lot. I think if
Okay.
you go above, if you see
Okay.
that Adarsh is asking, is it free to register the logo?
Free in the sense, what do you want to ask? Uh,
If you're talking
you
about.
can unmute yourself and you can ask the question.
Yes, Adarsh. If you're
Hello.
talking about.
Yes.
Yeah. So my question is about if I had designed a logo like by myself, and I had done a basic Google search about it. So if I do wanted to register it, I'm on a very I wanted to initialize the process. So how it is done, and how much that will be on the cost wise it will be.
Yeah. So as far as the trademark is concerned, so there are, and any other intellectual property. So there are two fees are involved therein. So first fee is related to statutory fee, and second fee is related to attorney fees. So attorney fees varies from office to office, and statutory fee, as Kirti has mentioned in her flow chart, that is physical filing and e-filing. The physical filing for startups, it is 5,000 rupees, and for e-filing, it is 4,500. So that is filing fee. And once you file the trademark, you may receive the examination report, you may appear for the hearing. And once you get the registration certificate, it will be registered for the period of 10 years from the date of filing. You can renew it by paying fees as well. So that is 10,000 rupees per 10 years you have to pay. So I'm talking about the startups category, and the fee will be higher in case of there is any large companies are applicant for this trademark.
Okay, understood. Thank you.
Yeah, thank you.
I think Roshan has raised his hand.
Yeah,
Yes.
you mentioned a point during the presentation that it is if I understood correctly, that both logo and the word mark should go together. You mentioned, right, something?
Yeah.
Could elaborate please on that?
Yeah, so you can register your trademark either as a word mark and or as a device mark. So these are the two types of the trademark, word mark or device mark. So in the word mark, you can actually register the word As Kirti showed you in her video, like Anuk, ANUK, that was a very, very inventive word which was used for one of the medical devices. So nobody can think of using that particular word. So in that case, if the word is very, very innovative and it has no any suggestive meaning, then it can be registered as a word mark. But nowadays, trademark registry doesn't accept this word as a word mark. So they usually, so it is always advisable to add any kind of logo, any kind of color combination, any kind of sound, etc. to along with your word, and then go for the registration of the trademark.
Okay, thank you.
Yeah. So I can see one chat over here. So if we
Really?
register, yeah, so from Akash Talke. So if we register a mark, for example, text Smart Health and a logo or image, so can company change the logo image and what is the process to update? So do you file fresh trademark or update existing approved trademark? So you cannot update the existing or approved trademark. You I think approved mean means the registered trademark. So that is what I understand. So you cannot change the registered trademark. You have to file a new trademark for any other thing. So as we have shown, there are various types of trademark, starting from the certification, collective, associated, series, etc. So depending upon your category, you can register the trademark in which category your new trademark fits in.
But
Ma'am, can I ask a further question on that? Like, let's say there was first cry example which you gave. So
Huh.
they had an option like just write a text like first cry in normal text. And what they have done is like they have given a logo to first cry. So
Mhm.
let's say in after 1 or 2 years they want to change the branding
Mhm.
and they want to change the logo. I understand you said that they need to file another trademark. But
Yes.
had they just written the text first cry, they would have got benefit in the first place and the second place also because they are always using the text and they're just changing the logo. So why
Yes.
are people using the logo? Like, can they not
So
just
there are two things, sir. So first thing is that if you file for a word mark, you can use it in any other color combination, any other font size, etc. But it will not catch the public attention, right? So the main purpose of the trademark is to distinguish the products or services from one organization from that of the other. So
uh,
I
can
can
you
see
please
the
mute
echo.
yourself?
Yeah, can you please mute?
There is background noise coming here.
Yeah. So thank you. So there are word mark as well as device mark. So it is always good to have a device mark which comprises of at least some kind of font size, at least some kind of color combination, at least some kind of device or a picture, etc. So it will catch public attention. It will be easy to remember. It will be easy to pronounce, etc. So in that case, it will gain a lot of brand value. So it is always advisable to have a device mark. The word mark, I understand that you can use it in any way you want, but you may not catch public attention in that case. So it may not be the distinctiveness. It may
But
not.
from a legal protection point of view, like first cry, if they had just kept the word mark and
Uh,
they would have used the logo anyway they wanted, and later on, like if someone had copied them, they could have like got protection because they had the word mark.
Yes, yes, but that is not their strategy adopted by them. So they have adopted the strategy. They can use these first cry mark. They have filed a lot of marks for their new products as well. So that should be the strategy adopted by the startups as well as the big companies also.
And if they directly go for word mark first cry, as you can see, it is two common words put together.
Yeah.
So it is going to be
Suggestive as-
very hard to get and first cry relates to babies. So babies, so it's like very suggestive of their line of products or services they are going to be providing in. So the chances of the getting those marks registered in the start itself without having some use to show that public relate to the first cry marks to them, it is going to be very difficult, as Archana just pointed out. So this would lead to some waste of your time as well and your investment as well. So rather than that, people usually have this strategy of going with device marks, showing the use, being in the market for many years, and when public is relating to those marks to them or their products only, then they go ahead with word mark because they can have plenty of evidences to show to the registry.
Yeah.
So that is the strategy people should go with, and especially startups, since they have limited number of resources and time to give in these
Yeah.
things.
Understood. My question is clear. Thank you. The answer is clear. Thank you.
So we'll move over to next question that is from Kasturi. So can we get a trademark registration in the 1 month, or there is any specific timeline? Yes, you cannot get the trademark registration in a 1 month from the date of filing. So once you file the trademark, the formality check will be passed, and after that you will get the examination report, or it will be directly accepted. But it has to be there on the trademark registry journal for 4 months. And after that only it will be registered or abandoned by the trademark registry.
And if you have an objection, then it will take another set of months to go ahead with.
So Dr. Tripti asked which is more authentic, TM or A. So I don't understand the word authentic. What does it mean? So as Kirti showed you in the slide, so TM is when you file for the trademark application, there is some timeline involved. Say 8 months to 1 year, and after that you will get the registration. Then you can put this R in a circle. But when you file for the trademark, then you can use the TM in a circle. So that is the meaning of it. So authentic in the sense you cannot sue anybody if you don't have the trademark registration certificate with you. Trademark law will help you once your trademark is registered.
TM on your own.
Yeah. So does that mean we can use TM on our? No, you cannot use your the TM on your own. So you have to file the trademark application, and then only you can use the TM.
You will get those common law rights we were previously talking about, that after you start using TM, you have some rights to claim. So those rights you are only going to get if you have already applied for the trademark and then you are using TM. Not just because you are using TM, it will not be given to you.
So next question is from Rama. So are there any government incentives, monetary, available for startups or companies in general for registering international trademarks? So unfortunately, so from the government, incentives are not available. Monetary incentives are not available right now. You have to pay on your own for this trademark. But yes, for the patents, various schemes are available. And you can search on related to these schemes on the.
Ma'am, this is the cost, ma'am. You had mentioned 4,500. So if you have Startup India certificate, will be 50% over and on the 4,500 amount?
No, those charges
No,
are for
sorry.
startups only. Those have this DPIIT DIPP certificates with
Or
them.
MSME for small businesses.
Yes.
So the cost is usually 10,000 for companies who are larger. Since you are a very small company or entity, that is why you are getting already 50%. So if you have a startup certificate or MSME, then your cost will be 4,500 or 5,000.
Yes, understood.
Yeah. So, Mr.
Yeah,
Neeraj,
can I?
yes.
This is Rama. So
Yes.
you said that there are some monetary benefits available for with reference to patents and something. Could you elaborate?
So this session is not for the patent. So this is for the trademark.
Okay,
So
okay.
if you want to know about those schemes, then you can write us separately.
Okay, sure.
Yeah.
So nothing for trademark?
No, nothing for trademark.
For international trademark, or there's no such.
Okay, thank you.
Yes. Then Mr. Neeraj asked, use means before registration. Yes, see, so sir, there are two things. So many people confuse with the patent and the trademark. So when the patent is considered, you have to file it before disclosing your invention anybody anywhere in order to protect your priority date. But in case of trademark, this is not the case. You can start using your trademark before filing the application as well. So as to strengthen your case, and as Kirti mentioned, you have to provide the use of the trademark in the form of documentation, maybe the invoices, the what you mentioned, the marketing flyers, etc. Yeah. So
So that means is it really desirable, and is it really more useful that we start using the trademark and the name, brand name, even prior to requesting for the registration?
Yes, because what happens is that once you have applied for the trademark, you applied on a certain basis that proposed to be used basis. There's a column to mention if you have been already using trademark. So many companies do that. Their trademark is suppose not strong enough. Suppose recently there has been a news that Haldiram has been given the status of well-known mark. So
Hmm.
Haldiram is a surname. How did they start, using these marks? So they used it for a good more than like 50, 60 years, and then they have like slowly started to register their devices, and through that continuous shown use, now they are able to prove to the registry that people only relate Haldiram surname with such snacks and food joints only. So now they are getting that status and recognizable.
So, but how to be very sure that that brand name or that conventionally we might be knowing that that brand name doesn't exist anywhere, but because it is a common name, then how to be sure that it is not already being used by someone, and then we can use it freely, and there will be no legal causes over there.
So for that, Katie showed you one slide. So you can do the searches on the respective trademark offices databases and the WIPO global brand database. And then the basically difference between the trademark is trademark and other IPs. When you start using the trademark, you will gain the brand name reputation among a class of public. And secondly, when you register for a trademark, it will be additional thing to strengthen your case. If suppose another trademark is cited by the trademark office in your examination report, and if you are using the trademark since a long time, then
Yeah.
you will get the benefit of registration and
So
the other. Yeah.
suppose I start using that particular brand name or trademark from today, and I don't get it registered for next 2 years, or let's say 1 year. And during this 1 year, someone else tries to file that name. Now I have been using, but that person registered or filed for registration the same trademark, and he suppose gets the trademark. Then my venture of using that trade name is now gone.
No, sir, there is provision. See, trademark laws always gives priority to usage rather than registration. But registration does provide for documentary evidence. So if you are able to provide documentary evidence that I have been using this mark for 2 years of time, that is way before the mark registered already, then you can pursue pursue the person and go for rectification of the mark. Rectification is a concept that a mark is already on the registry's books, but you are saying that they have wrongly registered with bad intention, so you want the registrar to remove their mark from the trademark registry books
So
and
if I
take yours. So you have
I
to
got it.
provide enough evidence there.
Yes.
So,
Sir, but it is always advisable.
if I try to summarize, I would say that step one should be to start using the name,
Yes.
Yes.
use it for some time. Step
Yes.
two should be registration of a trademark,
Yes.
not
Or
the step
it
one.
should,
Yes,
yeah,
please do the
depending on the mark.
registration. Yeah, please do the registration.
Specifically for the
But
common names.
yes, please do the registration, but because the trademark registration will give you the legal rights
Yes.
to sue.
No, I agree.
Yeah.
My question is that should registration be step one, or should using be step one?
Your very first step should be choosing a mark which is very good and has these elements.
yeah.
Novelty is there. I mean, equivalent to what novelty the concept is. That first mark should be that, and then you should apply for the trademark. And while within since the day
No,
you
no.
have applied for,
See,
you can start using.
why I am asking this question again and again, because
Yes.
in my mind the name
Have a
which
common
I'm
name.
is a combination of two very common words.
So
For
for those
example,
kind of
let's say fast friend. So
Okay.
fast is also a common word, and friend is also a common word.
But
Just an example.
you can check the availability of this trademark on the databases. If it is there, lot of things if you get, in that case, you may need to change this trademark.
No, I have checked it. And that name is not available as of now. So
Okay.
should I start using it, or should I register it?
So many factors would be involved. I don't think we can suggest on that right now.
Yeah,
We can have a further discussion about this mark.
Okay.
You can reach out to us, and after discussing many factors with the public searches, you can take a call then after you have all the
Okay.
facts
No
and
issue.
data
I got
available.
it.
Yes,
Yeah.
yes, we
So-
can do.
Another question is from Ravi Kumar. So how to transfer the trademark ownership from individual to company? So that is the assignment agreements are there. So you can transfer the ownership from individual to company. So that's not a problem. I hope all of you have filled up the feedback form. Your feedback is very, very necessary for us. and valuable for us as well.
How much is the attorney charges from the benches this TechX side?
We are not
those
attorneys.
charges, so,
Yeah,
so
first
those
we had-
charges are mentioned on our website. Please visit
Yes.
our website.
Okay. That will be good. Yeah.
Yeah,
Yeah.
so if you register a mark, for example, text Smart Health and a logo, then can company change the logo image and what is
Ma'am,
the?
you covered the
This
question.
question
Yeah.
has
Got
been
the point.
addressed, yes. Please share. Okay.
Ownership can be changed post registration through assignment and how much time it takes. So I don't think it should take much time. We need to fill up some forms, pay some fees and the assignment agreement, etc. And after that, it will be changed on a trademark registry website as well. So within a month or two, maybe we can say, we need to file a trademark for already registered patent. I don't
Sorry,
understand, Dr. Kirti. Maybe you can unmute yourself and just ask the question. Okay, I think we have covered all the questions. And one question is related to, do we need to file a trademark for already registered patent? So
Dr. Preeti Sharma, if you are still in the meeting, you can unmute yourself and ask the question. If not, we shall be ending the session now. I hope everybody has filled the feedback form, and thank you for attending this session. And feel free to reach out to us for any discussion or services you might require. Thank you so much.
thank you so much for attending and taking time out of your busy schedule.
Yes.
Thank you. So we'll end the session
We'll end
here.
the session. Okay.